Welcome to the Regulatory Transparency Project's fourth branch podcast series. All expressions of opinion are those of the speaker.
Hello and welcome to the Regulatory Transparency Project's fourth branch podcast, Explainer episode number 74. Today we are joined by Karen Harned, president of Harned Strategies, LLC, and Rosario Palmieri from Louis Brisbois. These experts will have a discussion on incorporation by reference and voluntary standards. Thank you, Karen and Rosario, for joining us today.
Thank you, Marie. And thank you those that are joining us today for a topic that many may know about, but many I suspect are hearing about for the first time in the regulatory arena. We are joined today by a great expert on this issue and many regulatory issues, as you'll learn through his bio, Rosario Palmieri, who is a partner in the Washington, D.C. office of Louis Brisbois, and he's co-chair of their administrative law and regulatory practice and vice chair of the Environment, Land, and Natural Resources practice. He's also a member of their government affairs practice. Rosario has served in past administrations. Most recently, he served as Associate Administrator of the Office of Information and Regulatory Affairs in the White House Office of Management and Budget. That's the group that oversees regulatory work by the agencies. He oversaw that regulatory review and analysis regarding energy, environmental, labor, agriculture, transportation, and tax regulations across the federal government. He also co-chaired an interagency working group on PFAS. Previously, he directed oversight of federal regulatory agencies and prepared legislation as staff director and deputy staff director of subcommittees of the U.S. House of Representatives. And he has also served as an association president and vice president of legal and regulatory policy for the National Association of Manufacturers. So thank you for joining me today, Rosario.
Thank you so much for having me, Karen.
Great. I will start with the first question for many, which is, what is incorporation by reference? What does this term mean? What what it is and what it is not?
Thanks, Karen. So when we're talking about incorporation by reference in this context, we're talking about when external sources, typically voluntary consensus standards, are incorporated by reference in federal regulations or in law. This isn't a conversation about incorporation by reference in contracts and contract law or in other sort of steps in a legal process. What we're really focused on today is when and how, especially the federal government, uses incorporation by reference to meet and achieve a number of goals for the federal government.
Now, I have to confess that I have known about this practice for a while, but did not know until I had spoken to you that there is actually a law that provides for it. So can you tell us a little bit about what, created this type of incorporation by reference?
Sure. So the history and practice goes back many decades. It has often been the case that federal agencies have relied on voluntary consensus standards promulgated by industry in their private capacity for a number of areas. So as an example, when OSHA was first created, it incorporated a number of voluntary consensus standards as mandatory standards for health and safety. Similarly, when the Product Safety Commission was started, it incorporated a number of voluntary consensus standards. But in 1995, Congress passed the National Technology Transfer and Advancement Act, which required federal agencies to prefer voluntary consensus standards when setting technical regulatory standards over government unique standards whenever possible, except where other laws precluded them from doing so.
Great. Now, what kinds of standards are we talking about here when we're talking about these? We're talking about this?
So I mentioned, product safety as an example, health and worker safety, financial regulation, chemical manufacturing, food safety, processing, sometimes aviation safety and performance. There are all sorts of production of voluntary standards that industries use to help set best practices and regulate. But there's a special kind of standards, so an industry best practice is not a voluntary consensus standard. A private organization setting standards in secret is not a voluntary consensus standard. But groups that participate in true voluntary consensus standards, often through an organization like the American National Standards Institute, or ANSI, are accredited and agree to certain parts of a process, ones that are open, that have balanced viewpoints and no dominant parties, that are fair and go through a process somewhat like the Administrative Procedure Act. There's, there are open meetings, there's opportunities for comment, and then a decision-making process that leads to most likely a consensus, but also one that respects the input of all parties and attempts to address, objections and concerns. And in those cases, they're known as voluntary consensus standards that are recognized by these bodies. And those are the kinds of standards that the National Technology Transfer and Investment Act, as well as OMB Circular A119, prefer and require federal agencies to go to first.
Now, so with regards to these private groups like ANSI, how does the regulated community know that this is even happening? How do they participate? Is there any notifications that go through the Federal Register or that sort of thing during the standard development stage?
So in the first instance, Karen, a standard development organization that is setting voluntary consensus standards isn't in the business of making federal mandatory rules, right? It's trying to provide for basically, industry self-regulation. So let's think about something that maybe wouldn't be the subject typically of a federal regulation. A corrosion standard for the performance of a building material or something like that. Again, not something typically you'd find in federal regulation. So they're working on these standards. They're trying to increase and improve performance, maybe to better serve the public or based on a strong understanding of the marketplace or weather patterns or others. But maybe within that process, they're also establishing a safety standard, one that might be important for how a product is installed and how to ensure the protection of worker health and safety. And so when one day a federal agency decides we feel the need to impose a government mandatory standard, the expectation is that the federal government would come to this standards development organization and work with them to see if their standard, their voluntary consensus standard, was appropriate. There are, for these groups, when they are an ANSI approved process or similar, they do provide notice. They do ask for participation by interested parties, and those interested parties include federal agencies. So federal regulators often serve on these standard setting committees. So do members of consumer groups, as well as labor organizations, and often important in the context of industry self-regulation, often an insurance company or similar, the insurance industry. So if you'd imagine or be concerned about an industry group setting a standard for itself that might be too lenient, you've also got people in the room, again, like consumer groups or federal regulators, or even an insurance company who's insuring that industry and wants to make sure that they're doing the best they can in that particular standard.
And so then do companies and or trade associations also participate?
So often it is a trade association that is the sponsor of one of these standards development bodies. So as an example, the American Welding Society or the American Petroleum Institute might be setting standards and specifications for the products and equipment that they use. Similarly, as we talked about with the history of OSHA, for example, OSHA at the beginning of its formation, because it had no standards or particular rules or regulations to rely on, Congress gave it the ability within its first 2 years of its formation to adopt any number of voluntary consensus standards that were out there. And so it had adopted a number from the National Fire Protection Association or similar industry groups. And as an example, the American Welding Society has a standard for the health and safety of its workers while engaged in welding. So these are the kinds of things that regularly occur. And I think what we often forget is that as vast as the federal government is, as vast as the federal regulatory apparatus is, we don't want it to cover and regulate absolutely everything that happens. And so the private sector, working alongside the nonprofit sector, fills the void and attempts to establish tens of thousands of standards for products and services and systems regularly through these types of standard development bodies.
That's really great. And so do they, so as far as, I guess, your experience, because you've seen this from the Hill, you've seen it, from OIRA, you've seen it from your practice as trade with the manufacturers and the other association you ran. Like, what are some success stories that you've seen, and have you seen any where you've seen concerns raised through this process?
Sure. So we talked a little bit about product safety and the Consumer Product Safety Commission. When the Consumer Product Safety Commission was created, it had sort of existed within the larger Health, Education, and Welfare Agency at first and was spun off. But, it was given an incredibly broad mandate. It regulates more than 15,000 categories of products, which, again, I think both to promote innovation and competition in the marketplace, a federal agency trying to regulate every one of those product category and every new category of consumer products would make very little sense. And so there are thousands of of voluntary consensus standards that protect the consuming public from unsafe products. And that's the private sector at work. In many cases, there are no market failures or reasons for the federal government to intercede. And that's a system that's working. From time to time, the CPSC will determine that that such standards aren't working, either because of non-participation by a significant part of the industry or international imports that might be coming from companies that aren't following those standards, and may determine that a mandatory standard is necessary. And so in that Consumer Product Safety Act that formed the commission, there is an expectation that they first go to and rely on those voluntary industry standards, because often what might be missing is just a full participation in the marketplace in that voluntary industry standard that was produced by incredible expertise by a number of key stakeholders, again, which can include the federal agency, consumer groups, labor, insurance community, et cetera. And so to me, that's a system that has worked for a long time. There are others where you might find no need for regulation. Building energy efficiency. It's not atypical for groups to decide to meet voluntary standards for building energy efficiency, like those produced by the Green Building Council or similar. And instead of the need for stronger and stronger mandates or regulation of that part of the sector. Similarly, in the financial services world, there's long been sort of industry self-regulating organizations like FINRA, which is sort of a different breed. And again, so much of the health and safety regulation that we rely on are parts of industry self-regulation and voluntary consensus standards. I think I mentioned earlier the National Fire Protection Association. Again, sort of the group that we most rely on for fire protection, both in the workplace and in a number of other settings, just really sort of the gold standard. And we don't need a national fire protection agency because there are appropriate incentives in the marketplace for systems like that to work. And there's an entire body of private sector testing agencies that are also helping to make sure and certify that a company's products are consistent with a standard. And so as a company, you can say, my products are tested to this standard and meet this performance standard. And so it gives consumers sort of a good housekeeping seal of approval, an opportunity to ensure that the products that they're purchasing, or for business to business, the products that they're purchasing are meeting certain standards. And also it helps facilitate international trade, because often these standards become global standards. So American national standards often become global standards. And so also to protect and support that process, we think it's really important that the federal government continue to support this process and to not establish government unique standards when it's not necessary.
Great. Now, one of the things that I know has been an issue, and, putting on my small business hat here, is, there's been complaints about transparency and accessibility. And I know the Administrative Conference of the United States had some recommendations back in 2011 with regards to this. And, not surprisingly, those groups like ANSI that develop these standards have, copyright protections for what they've developed. Can you describe a little bit about how ACUS, what their recommendations are, and just, some, I guess, for lack of a better word, best practices that can be done there to make sure this process is more open, especially to those that, like smaller businesses that it's all they could do to keep up with the Federal Register, much less find out what ANSI's up to.
Absolutely. So you've reached one of the sort of critical trade-offs, which is because these standards are produced by private organizations, that when the government adopts them and incorporates them by reference in the U.S. Code or the Code of Federal Regulations, those standards aren't there, right? Aren't in the code. And so you've got to go find them and reference them elsewhere. And because many of these standards are copyright protected, it means there might be a fee to purchase and use these standards. And so there's that critical issue of, well, does this meet the obligations of federal agencies to ensure that all this information and all of the law that people are subject to is readily available, or, as in the Federal Register Act, reasonably available? And so what ACUS recommendation from 2011 sets out is that agencies should be cognizant of this trade-off. They shouldn't attempt to eliminate copyright protection, because we believe that that's a critical property right, but they should endeavor to make these standards reasonably available. And so often the agencies have been able to make copies of these standards available in their electronic docket during the rulemaking process. The ANSI and many of the standards development organizations have set up an online portal, literally called Incorporation by Reference portal at ANSI, to provide read-only access to these standards so that anybody can read them. They just can't copy and download them or sell them or make copies without a license from the Copyright Authority. And the reason that many of these standards are copyright protected is simply because there's a cost to produce these standards. There's hundreds or thousands of hours of work that goes into these processes, literally because they're open. They conduct, ballots and votes and provide opportunities for public comment. And there are, staff and expertise that have to go through all these comments and review them. And the sale of those standards or license of those standards is often a source of revenue to support that process. Also, sometimes these trade associations that serve as standard development organizations, right, there are membership fees. But again, those should not be a barrier to the public's ability to view these standards. And so a vast majority of them are available in some way, or available in libraries or other places. But I think you're especially right. The more sensitive, the larger the audience for a requirement, the more important accessibility is. And so they continue to work to strive for that balance. And ultimately, that ACUS recommendation also says that this should be a consideration for when the government decides to use a voluntary consensus standard versus its own government unique standard, is the level of accessibility and the ability for everyone to know what the law is.
That's great. So before we conclude, looking at the issues of the day, so to speak, you and I have talked that it would look, we've all had the joy of watching legislators grapple with, social media and artificial intelligence, and it's pretty clear, they don't know a lot about what they're talking about. It seems to me that might be a good area where this type of thing could be helpful. In addition, I know right now we're looking here in October of 2024, we're in the middle of a comment period from OSHA, and you'd referenced that before on their heat standard. And I know there's been some concerns expressed by OSHA attorneys and others that that regulation, could be maybe drafted in a way right now that would prevent companies that are doing best practices on heat-related illness from continuing those. I mean, are those the types of things that you're seeing with our current, look? Is there our current issue set? Are there others that you think might be ripe for this kind of voluntary consensus, industry standard building exercise?
Absolutely. I mean, I think we've always known that that the private sector is uniquely qualified to understand the programs, the technologies, the products, the systems that it's producing. And so, whether we're in a mandatory regulatory standard process, you need and want that expertise involved. But often, especially with emerging industries and emerging technologies, the government has, a pacing problem. It is unable to keep up with the pace of technology. And at one level, we wouldn't want the federal government to be able, to produce a regulation for every new technology, every new product. We expect some nimbleness, and we expect the market to be able to deal with a number of things. And so, as you mentioned, AI, social media, and others, right? There's an expectation that self-regulation works first, that we don't intervene on the federal side unless there's truly a market failure. And there's often considerable debate about that. And I would just mention, since you mentioned the heat illness standard from OSHA that's recently been proposed this year, there also have been examples where federal agencies will rely on non-consensus standards, private bodies that develop their own standards or expectations in private, like a group called the American Council of Government Industrial Hygienists, which has often been the source of OSHA standards for threshold limit values and others, and had, sort of put forward its own standards and approach to heat-related illnesses. And thankfully, at least in part of this rule, OSHA did not adopt those. But I think we should always also be cognizant of the fact that government sometimes relies on those non-consensus bodies. And so promoting the voluntary consensus standard process, I think can be incredibly helpful. There's also just places where I think we, and certainly Federalist Society members, don't believe the government has a place to regulate or to participate, like ESG standards, for example. And so I think we also don't want, just because there are some voluntary standards out there, again, not often voluntary consensus standards, in an emerging, group or others, it may not be appropriate for the federal government to adopt them. So I think this is a note of caution, which is not all private standards are created equal, and the federal government should continue to look for those voluntary consensus standard processes that are really helping, I hope in many ways, to limit the size and scope of the federal government and its participation in the broader regulation of everything.
Well, that is great. Rosario, this has been so helpful. I really appreciate your time and expertise. I've learned a lot, and I'm going to confess I came in very skeptical. I'm probably not 100% of a sell, but you got me a lot farther the way than I was coming into this conversation. So I really thank you for that. Maria, I'll turn it back over to you.
Thank you, Karen, and thank you, Rosario, and thank you to the audience for listening in. And we'll see you next time. If you want to find out more, go to fedsoc.org. And again, we'll see you next time.
On behalf of the Federalist Society's Regulatory Transparency Project, thanks for tuning in to the Fourth Branch podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.